we continue looking at the divorce case between Dr. and Mrs. Sinclair. We're now at submissions on behalf of the defendant. So these are the submissions by Ms. Annalicia Lindsay, the attorney for Dr. Sinclair. Counsel for the defendant submits that Mrs. Sinclair has exhibited several medical reports that she claims support her assertion that she cannot work. However, none of these reports support that assertion. Most of them speak to procedures that the claimant, Mrs. Sinclair, may need and has requested that she be afforded the requisite time off from work to be able to recover from those procedures. There is no evidence before the court that suggests that Mrs. Sinclair cannot work. She further submits that it would be in keeping with the clean break principle that Mrs. Sinclair eventually works to support herself, given that she has admitted under cross-examination that she was an accountant when Cherry Gardens property was bought, and then described herself as an auditor when the Ruthven property was bought. In any event, the professions listed and admitted by the claimant, Mrs. Sinclair, underscore that she is a trained professional capable of obtaining work. She is of the view that the claimant, that's the lawyer, is of the view that the claimant has not made genuine efforts to obtain work. She refers to the case of McEwan versus McEwan, 1972. Counsel for the defendant has also taken issue with evidence of the claimant. So counsel from Dr. Sinclair has taken issue with evidence from Mrs. Sinclair that she took several loans to manage her expenses. She points out that the receipts put forward by Mrs. Sinclair have provided no details as to the purpose for the sums stated on them. So, the court should reject these as evidence of any loans at all. She further submits that if the court is minded to accept the evidence of these loans, these would be loans for substantial amounts of money. It is therefore arguable and can be inferred that Mrs. Sinclair, in obtaining these loans, has the requisite resources necessary for persons to have confidence in these loans, that these loans will be repaired. So she must have presented something to say that I can repay you these loans. She is of the view, that's Dr. Sinclair's lawyer here, is of the view that the defendant, Mrs. Sinclair, is not being a party to these loans. The defendant not being a party to these loans should in no way be held responsible. So Dr. Sinclair is not a party to these loans. He did not authorize or allow or agree to them. He should in no way be responsible for the repayment of those loans. She submits that the sum of $150,000 being paid by Dr. Sinclair is reasonable in the circumstances, and that the defendant, Dr. Sinclair, should be ordered to continue to pay the monthly maintenance of $150,000 to Mrs. Sinclair for a period of 2 additional years from the date of the order. She is of the view that since their separation in 2017, Mrs. Sinclair, Dr. Sinclair, has been supporting Mrs. Sinclair. He should not be held to provide this support for an indefinite period of time. She points to the medical condition of the defendant, Dr. Sinclair, as well as his continuing obligations as a father in providing for his children, the youngest being only 10 months old. She asks the court to take into consideration the following. 1. The financial support that the defendant continues to provide to the children of the marriage, including university fees and living expenses overseas. 2. Maintenance of his other 4 children, one of whom has a special condition and whose expense may vary from time to time. 3. Mortgage payment on the family home. 4. Several loan obligations, including loans acquired in the purchase of the very vehicles that Mrs. Sinclair claims, but without the liabilities. And 5. Having moved out of the family home, rent for his current accommodation, together with the attendant utilities, groceries, cable, and other personal incidentals. She adds that the expenses for the defendant, Dr. Sinclair, outlined total approximately $3 million, and that neither Mrs. Sinclair nor the defendant are particularly young, and as such the burden of any sum above $150,000 imposed on the defendant may only serve to ensure that he is in default and incapable of surviving to continue to earn to provide for himself and his children, whose interests are paramount.